So today's topic here, dealing with COVID, how businesses can deal with COVID. We have 4 different major topics. One is obtaining financing from governmental programs and other sources. Number 2, how to deal with creditors, creditor problems, how to fend off those creditor issues. Number 3, is a small business bankruptcy, is that an option that you should consider? And then finally, dealing with staff reductions, sick leave, and other employment issues that may have popped up as a result of the COVID-19 pandemic. So just to get started, I'm going to turn over to Steve Magala on financing options.
All right. Thanks, Ted. Go ahead and go to the next slide. So we kind of break down the financing options into kind of 2 broad categories. First, you have governmental programs, federal, state, and local. And then we'll touch on alternative financing with respect to subordinated debt, subordinated lenders, and factoring of accounts receivable. Next slide. All right, so with respect to the federal programs, probably the biggest one that everybody's heard of is this Paycheck Protection Program loan. The link is there and the slides. And the slides will be available by the SBA. You guys can download them at the end of the presentation. And so you don't have to worry about taking notes or anything like that. So all the links and everything are there. So you'll be able to get those slides at the end. Unfortunately, the PPP loan program is closed. And so really now the focus is on, for those who obtained PPP loans, now the focus is on forgiveness of those eligible expenses. So if you do have a loan or your clients have a loan, you make sure that they are focusing with their lender on getting those loan forgiveness applications in. The PPP interim final rules with respect to forgiveness are available at that SBA's website. Next slide.
If I could jump in real quick, it is, as Steve mentioned, the focus right now is on forgiveness of those PPP loans. There's 2 different applications on those. An easy one, there's a long form. I would encourage anybody who took out one of the loans to sit down with your accountant, make sure the application is filled out correctly, take advantage of getting that forgiven. And in addition, there's some issues of, is it includable in income? A lot of times, the general rule is when a debt is forgiven, that's supposed to be includable in income. Well, in this situation, there's an exception to that rule. But then in addition, the expenses that you satisfied using those loan proceeds, those are not deductible. So there's a couple of tax issues that pop up there. So as a result, I would definitely encourage you to spend a little bit of time with your accountant to make sure it's handled properly.
For sure. Thanks, Tom. All right, so the SBA has been pretty active on this front. The first program I want to mention here is the SBA's debt relief program. So the SBA, if you're a current lender under their 7A, 504, or microloan program, and those loans were dispersed prior to September 27th of this year, then they're going to pay 6 months of principal, interest, and any associated fees. So that's a very good feature. And so definitely you want to make your clients aware of that if they do have an SBA loan. So next slide. The SBA also offers economic injury disaster loans. It was expanded as part of the CARES Act. And here you're looking at up to $2 million loan, interest rate of 3.75% with a term of up to 30 years. The key criteria here, as you see in the slide, is they can't really have any other source of credit. So, if they're able to get a loan from their bank, they probably wouldn't qualify for an EIDL. It covers most operating expenses. Unlike the PPP loans, these are true loans. However, there's an exception where you can get an advance of up to $10,000 when you apply for an EIDL loan. And if your loan application is rejected, that advance is essentially forgiven. So other than that aspect, it is a true loan. And if you're applying for a loan of more than $25,000, then the SBA is going to require collateral for that loan. So that's another thing to be aware of. Next one. All right, relatively new program, but that's kind of getting a lot of attention is Federal Reserve's Main Street Lending Program. The 2 links here, first is the Federal Reserve's website describing it, and then it's kind of our summary of it as well. There's 3 facilities here. There's a new loan facility, priority loan facility, and expanded loan facility. Really, the third one, the largest one, is the expanded loan facility, and that's for if you have an existing loan already with the bank and you want to upsize it or add a new increment or tranche. So really a lot, I think for SBA purposes, a lot of the loans that probably the SBA members would look to receive under this program would fall in the new loan or priority loan categories. So here you're looking at 5-year loans at LIBOR plus 3%, which is, I guess right around probably 3.25% total right now. And the good feature of this is that principal payments are deferred for 2 years. Go ahead and go to the next slide. So here, this is kind of a quick summary table of the various loan facilities. So again, here you'll see the first row term, they're all 5-year term loans. Minimum loan size, again, for those first 2 loan facilities, which are going to be the primary loan facilities, I think, for the SBA members, $250,000 minimum loan sizes. 1, 2, 3, 4, 5th row down, interest deferral is also a good feature there. You can defer interest and have it capitalized for 1 year. As I mentioned, there's deferral principal for first 2 years, so they kind of make you pay it on the back end, years 3 through 5, and you see kind of the percentage breakdowns there. I mentioned the interest rate already, LIBOR plus 3%. It may or may not be secured depending on the type of facility you'll see there in that row. One thing I do want to mention with respect to these new loans, with these loan facilities, is sole proprietorships are not eligible, and that the borrower must be in existence before March 13th, 2020. So these are really more for kind of established businesses already. Next slide. Okay, so let's turn to the state and local programs. Like with the federal PPP loans, which are kind of already allocated and dispersed, the state's looking at a similar situation here with respect to a lot of its funding programs. Things like the big grants, the Small Business Emergency Loan Fund, this Hospitality Emergency Grant Program. A lot of these programs were initiated, in March, April, and they've already allocated their funds. So, certainly I encourage you, either individually or through the SBA, to lobby your state and federal legislators and try to get some more funds allocated for these programs, or just get some more relief in general. I know Kane County has an informational webinar. They're launching a coronavirus relief fund. That webinar is coming up on September 18th. And I received word from Cook County that they're launching something as well, kind of a similar type of coronavirus relief fund program. I think, Lisa, you have more details on that, right, in terms of what that Cook County program might look like?
I do, thanks. Yeah, so Cook County is putting out recovery grants. They're going to be $10,000 per grant. These are grants that are going to be available for businesses located within suburban Cook County. So to be eligible, companies have to have fewer than 20 full-time employees with business and sales reduced 20% in any month from this past March through July versus February 2020. It is available for profit companies. Nonprofits are not eligible, but this program will be launching tomorrow, I believe. So as soon as we get information, the Schaumburg Business Association, the other SBA, will be promoting it quite a bit. They'll be doing weekly webinars as well, and it will be open for about 6 weeks to receive those applications, at which point they will be giving out about $15 million.
That's great news. And so can we look at that website there at the bottom of the slide, Lisa, for any updates from you guys? schaumburgbusiness.com/coronavirus. Perfect. Yeah, so monitor those 2 sites there. The first one is the Illinois Department of Commerce and Economic Opportunity website. And then the second one is, of course, our SBA website for the coronavirus updates.
Steve, right. Before you move on, we had a question just pop up in the chat. Do you know, heard anything about county relief grants or loans?
Which counties?
DuPage.
I have not. Is anybody else on the panel aware of anything from DuPage? I've not seen anything. Doesn't mean there's, probably not something there. I'm just not aware of it. So, all right, next slide. All right, so the Village of Schaumburg here also has a grant and a loan program both. The grant program there, the website's there for both programs. You can click on that at your convenience. The grant program is for 50% of eligible expenses for small businesses, up to 2 months and up to $10,000. The loan program, there's a geographic preference given to that area I noted on the slide there, south of Wise Road and between Mitchell and Rodenberg, kind of more of an industrial area. But so that's more of a geographic preference. I don't know how applicable it would be to the SBA membership as a whole, but wanted to throw that out there as well. Okay, next slide. Finally, there are alternative financing sources. Now these are going to be more expensive, obviously, than some of your other sources, typical traditional sources of financing. You could try to get a subordinated loan from a lender. But again, because that loan's subordinated to the primary bank debt, it's going to carry higher interest rate and more risk. The same thing with kind of accounts receivable factoring, which is essentially a sale of the accounts receivable. And here, those are good situations in which you can obtain primary financing from a traditional bank. But again, kind of the same situation, the interest rate or kind of the cost of that financing is going to be a lot higher. But these are our sources that you can use kind of in a pinch to obtain liquidity and cash flow. So next slide. So that concludes my presentation on financing options. I guess we can open it up for questions on this topic. Otherwise, we can move on.
All right, well, let's move on to the next topic, and that's dealing with deferring payments and fending off creditors. All right, Steve, you want to jump in there?
Right, so here we kind of break up our presentation into kind of 3 broad categories. First, just dealing with contract issues generally, so things like vendors, suppliers, and different other contracting parties that your business deals with. And then second, we'll talk about landlords and leases. And third, we'll talk about how to deal with lenders and existing loans and loan documents.
All right, so contract issues. Let me jump in here, Steve. Many times if you're having a difficult time with your business, cash flow is not coming in, you have vendors coming after you, sending out demand letters, threatening to sue you. The first thing I would say is that you have to understand that creditors do not want to file a lawsuit. They don't want to do that. It's risky for them because they're going to have to front up more costs with their attorney. It takes a long time for them to bring a lawsuit. So you as a business can use that as leverage and take advantage of that. Use that leverage and try to use that to negotiate either more time and help yourself out. Now, the first thing I would do when you have a vendor or a creditor coming after you, it typically will arise under a contract. And normally that contract is in writing. Not always. I understand sometimes there are oral agreements, but assuming it's a written contract, the first thing I would do is get out your written contract and review the terms. What do the terms say for performance? A vendor or creditor is coming after you, claiming you're in breach. So what does the actual contract say as far as performance? When is performance due? And furthermore, is there a cure period? Maybe there's a period of time where you can cure. Maybe the creditor has to send notice to you before they can declare a default. So get that contract out, review those terms, and take advantage of any language that's in that contract that you can use to leverage and negotiate additional time. Another provision, if you're dealing with lender documents, maybe a loan with a commercial lender, a lot of times there are covenants in those loan documents. And based upon the circumstances and the financial, operations of your business, there could be some breaches of those covenants. Steve, do you want to jump in there? I know you do a lot of the lending transactional work. Do you want to comment on material adverse change clauses and covenant defaults?
Yeah, there's been litigation coming down the pipe with respect to material adverse change, material adverse effects, terms. A lot of these are still kind of being litigated, but this kind of comes into play with respect to, I tend to mention loan documents, also with respect to any sort of transactions, things like mergers and acquisitions, larger transactions that have these types of clauses, and really kind of the issue with whether COVID-19 comes within that kind of scope, and if so, whether then that gives the party looking to terminate the deal the ability to do so.
Thanks, Steve. Okay, so another issue that comes up quite a bit is force majeure. It's something that's been mentioned several times out there. I'm sure everybody's been looking to see if this is applicable. What force majeure is, it would be a clause in your contract that would excuse performance as a result of some sort of act of God or some sort of unforeseen occurrence. So first of all, there has to be that provision in your contract in order for you to take advantage of that. But if that clause is in there, then you got to read the language and see specifically what it says. And then a lot of times the debate becomes about whether or not this event, this COVID-19, I guess, in this situation, is that an act of God that would excuse performance? There has been a recent court decision in Hit's Restaurant Group, and I'm kind of surprised that we have this decision now, because typically, litigation takes many, many months, if not years, and it's a long process. But we have a decision that was entered this year dealing with this interpretation of a force majeure clause. Now, in this case, it was dealing with a landlord-tenant breach, and of course the shutdown order for the state of Illinois, and whether or not that excused the obligation for the tenant to pay rent. The court ended up holding that the March 1st rent payment remained due as provided under the lease. The reason being is that the shutdown order did not take place until later in the month of March. So that March 1st due date, that rent would be due. Now, there was a partial order or decision on this that helps the tenant, and that was that because of the shutdown order, the tenant was only able to utilize the kitchen. The court held that that's 25% of the space, and therefore going forward, while that shutdown order was in place, the tenant was only obligated for 25% of the rental payment. So there's a decision that you can use that may be helpful for you if you have a contractual dispute. And again, you got to look at the contract, see what that language says, but there is a decision there on the books that could be helpful for you. Now, the last concept I want to bring up here, and this, we don't have a slide for this, and this deals with those situations where you may not have a contractual provision that you can hang your hat on. And that's the doctrine of impracticability or frustration of purpose. What that means, if there's some sort of unforeseen event, a party's performance could be excused. Now, for that to be applicable, the event must be unforeseen. And I want to point out that economic inadvisability is not good enough. So in other words, just because carrying out your obligation under a contract is more expensive or it's going to not be as profitable for you anymore, that's not good enough of an excuse. One example where we used this year was we had a client that had a contract for a holiday party, and because of the limitations, to only 50 people or less, this particular client had staff exceeding 100. So we were able to use that doctrine to negotiate with that creditor a mutual separation that made sense for all the parties. So again, it comes down to leverage. Can you use something to leverage negotiation that is acceptable to you? That's where I would, that's what I would try to do in these sort of situations. Steve, you want to take it away?
Right. So the next category then is landlords, and like we mentioned before, you got some case law now that's very favorable from the Northern District's bankruptcy court, kind of allowing for a reduction of rent. So here we can kind of, if I'm representing a tenant, I talk to the landlord about trying to get some rent restructuring in place. And landlords are, like, especially if you're a retail space, they would rather have you pay some rent or somehow, maybe restructure the rent, defer it, put it on the back end of the lease, whatever, versus evicting you, which is long, a lengthy process and costly, and then not having any rent in that space. So I think there's some flexibility there with landlords to have some sort of ability to renegotiate the lease. Of course, it depends on the type of use and what your business is. So there's that possibility.
And a little bit later on today, we're going to talk about small business bankruptcy, and that is an area, another strategy that you can use when you're dealing with a landlord. So we'll get to that a little bit later.
Okay, next slide. Oh, okay, there you go. So there are moratoria in place with respect to landlords and evictions and leases. These are both of these here from Pritzker and from the CDC. They all have to do with residential real estate, so they don't really touch on commercial space at all. But I just wanted to throw those in there to make sure that you're aware, especially if you have a home-based business, for example, these could apply. So first, we have Pritzker's order. That website there shows you where all the executive orders are. I know it's his order is extended through September 19th. I don't know if he's extended it, and I'm not sure, frankly, if he needs to extend it given the CDC's moratorium there in the second bullet point. And that one there, you have a moratorium for the evictions of residential tenants through the end of the year. Now there's some qualifications there under the CDC's moratorium. There it applies to I guess what are called qualified renters. So you have an income requirement there. Tenants have to certify that their income is less than or equal to $99,000 or $99,000 per year, or $198,000 if they're joint filers, that they're unable to pay their rent due to lost income or extraordinary medical expenses. So things of that nature that would qualify them to be to receive this the benefits of this moratorium. And then note that this moratorium only really excuses the payment obligation by the tenant. The landlord is expressly allowed to continue to collect late fees and interest and any other charges that may be due under the lease. And it does not remove the tenant's obligation to pay rent, it just defers it. So there's still whatever rent has been, whatever rent is due, it is still due. It's just you can't evict, so that rental obligation exists and continues to accrue interest and late charges and all that. So next slide. All right, so with respect to lenders, there's a similar moratorium. Again, if you have a home-based business, these are all for residential properties. The first moratorium is with respect to foreclosures. It applies to single-family mortgages only that are backed by Fannie and Freddie. And then the evictions aspect, that evictions moratorium applies to properties that through foreclosure or deed in lieu process have become, those properties have become now owned by Fannie and Freddie. And there, that's when the evictions moratorium would apply. So it applies to basically, homes that are owned by Fannie and Freddie, and it does not apply to tenants in homes that have not yet been foreclosed. So I wanted to make that distinction as well. Okay, next. When dealing with lenders, especially if you're kind of in a pre-default stage, there hasn't been a default declared yet, you have some more options. If you're a business with a loan and loan documents with a commercial lender such as a bank. Here, if you do have lines of credit available, you can certainly consider drawing those down to provide liquidity and cash flow. But you should really kind of take a look at your loan documents before you do that and think about that, because oftentimes in these loan documents, you'll see that a draw request is an affirmative representation that no default exists or will arise. You want to kind of make sure that that's going to be true. If not, that could cause an event of default. It also creates tension with the lender, right? So if you're kind of drawing down your availability, all of it, at once, that's going to, kind of raise your eyebrows a bit and kind of create some tension there with the lender. So you want to think about, how you want to do that. And then also maybe as part of that, talk to the lender. Again, just like with landlords, lenders are going to generally be willing to work with you So talk to them about loan amendments and forbearance agreements. We're seeing a lot of those with respect to both our bank and borrower clients, working with and drafting and preparing these. And it's really a good solution if there's a light at the end of this tunnel here for a borrower. If the lender, if you can convince the lender that things will turn around at the end of this, they're more likely than not willing to work with you. A typical forbearance agreement is going to be 30 to 90 days, at the end of which the parties will kind of go back to the bargaining table and try to figure out what the next steps are. But these are all options that are good for when dealing with lenders. So that kind of concludes our segment on deferring payments and fending off creditors. Does anybody have any questions at this point on that topic?
Yeah, I got a couple of questions. One, on the force majeure clause, do you guys see in the future more people asking to have something like that put in their contracts after things like this has happened? And is it possible to get it in now after something like this has happened?
Yeah, I'll take that. So absolutely. I think 100% you're seeing that topic come up when we start working on contracts today. A year ago, force majeure was largely overlooked. I mean, what's going to happen? When's there going to be an act of God? I mean, it's never going to happen. And so it really was a forgotten term and really overlooked, kind of just thrown in there, tossed in there. Nobody really spent any time on it. But for today, 100% absolutely, people are going to spend more time on it, looking at it. And to your question, well, can you get it in there? Certainly that's going to be part of the negotiation. It's going to be another term that's going to be negotiated, and it comes down to leverage. Which party has the better bargaining position will typically dictate the language of that force majeure clause. But you're absolutely right.
And the contracts I'm handling, especially if it's going to be beneficial to my client, I'm definitely making sure that the force majeure definition includes pandemics.
And are you guys under the belief, which I always have been told for a variety of reasons, the best thing to do if you're having any kind of problems with your lenders is to let them know right away. Don't put it off. Don't hide from them. I read this and heard this from several people that if you get into a situation, the best thing is to tell your lender there where you may have a better way of dealing with it.
Agreed, definitely.
Yeah, Chad, we're adding that the force majeure in all of our letters of intent now. We're getting it right out on the table before we even go to contract. So trying to be forward thinking for our clients.
Yep.
Especially as we get towards fourth quarter and the flu season's coming back, and who knows where this is going to end up. So yeah, I mean, you're wise to do that.
Other questions? Okay, let's move on to the next topic. Small business bankruptcy and the Small Business Reorganization Act of 2019. So first of all, I want to kind of give you a bankruptcy overview. And again, we're dealing with business bankruptcies here today. When you start looking at bankruptcy for a business, they largely fit in two different categories. One is a liquidation, which is a Chapter 7, and the other is a reorganization, or Chapter 11. A liquidation, the business ceases to exist. It's no longer going to operate. At that point in time, the business terminates. And at that stage, the only action left to be taken is the liquidation of the assets that is performed by a trustee that is appointed by the United States Bankruptcy Court. It is his job to try to maximize what he can get on the sale of those assets. And then those proceeds would be distributed to the creditors, pro rata based upon their various claims and their priority under the bankruptcy code. Now, the trustee could also utilize some actions to recoup certain preferential payments. Those are payments made to creditors within 90 days leading up to the bankruptcy, and then also recover what we call insider payments. So those are out of the ordinary course payments to insiders. Insiders are shareholders or officers or directors of the company. It's just a tool that the trustee can utilize to increase and maximize that bankruptcy estate. But for the purposes of today, just understand a Chapter 7, that's the ending of that business. The business no longer exists. So now we move on to Chapter 11. Chapter 11 is a reorganization. What does that mean? What that means is the business is going to continue. There's a term out there, debtor in possession. What that means is that the debtor continues to own the business, continues to operate that business. But with a reorganization, you're going to restructure your debt. You're going to take that delinquent liabilities and you're going to satisfy those liabilities over a 3 to 5 year period pursuant to a bankruptcy plan. Now, the one thing about a reorganization, what is good, Chapter 11, it does create an automatic stay. An automatic stay puts a stop to any of that collection action that may be taking place. If you have a creditor that filed a lawsuit, well, that's going to stop that state court lawsuit. If you have the IRS problems, if the IRS levies your bank account, if you file a bankruptcy, that's going to put a stop to that levy action. Or if you have a problem with a bank, they may sometimes self-help by seizing your bank account. So all those collection actions, it makes it impossible to operate your business. What Chapter 11 bankruptcy puts a stop to those collection activities. And the last thing I would mention, to do a reorganization, you have to have a viable business. You have to have a business. Your core business has to be able to continue to generate cash flow. If you don't have a viable business, a Chapter 11 is not going to be successful. You're not going to be able to get through a Chapter 11 plan. So what's the problem with Chapter 11? Well, historically, Chapter 11s are a problem for small businesses because they're very expensive. You have to have a lot of cash flow to successfully get through a Chapter 11. And now you're probably scratching your head wondering, if I had a lot of cash flow, I wouldn't need to do a bankruptcy. So historically, Chapter 11s were for large corporations, your Fortune 500 corporations, big operations. They really weren't available for the small business owner because it was just so expensive. Why is it so expensive? Well, you have to, of course, you got to pay your own attorney. But with a Chapter 11, the creditors, they also have a committee that is created, and you have to pay for their attorney. You also have to pay monthly fees to a Chapter 11 trustee. In addition, you have to file monthly reports with the bankruptcy court. So that means you have to have an accountant. You have to pay them on a monthly basis. So it gets very expensive. So the Small Business Reorganization Act of 2019 came along, and it just created a tremendous opportunity for small businesses. It created a Subchapter 5. What is Subchapter 5? Well, that is a reorganization, but it's for a small business. It's streamlined. It's less expensive. Now, you do have to have a commercial or business activity. What that means, it's typically not available for a real estate operation. And then there's also a debt limit. When it was first passed, the debt limit was $2.7 million. As a result of COVID, they increased that debt limit for 2020 up to $7.5 million. But this is just a tremendous opportunity for a small business to reorganize and keep your business going. Now, some of the features of Subchapter 5, like I mentioned before, it's a quicker operation. Number 2, the debtor is the one that's going to be in controlling that plan. You don't have to have a creditors committee propose a plan. There's no new value rules. So a lot of times in a Chapter 11, the shareholders end up losing their equity. In a Subchapter 5, that's not the case. Fees are less, and there's additional flexibility. So it's just it's a great opportunity for small businesses to kind of keep your business, buy more time, and survive. Now, what are some of the strategic uses? Now, I mentioned earlier that in the commercial lease section, this is a good opportunity. What I mean by that, in the Subchapter 5, the debtor has a power to terminate that lease. So if you're in a situation where maybe the market has fallen and the square foot of rent that you're paying exceeds market level, or maybe you don't need the space that you needed before, you could terminate that lease, which puts a stop to any future lease obligations. Now, if you have delinquent rent, you got to take that delinquent rent and you got to put it in a Chapter 11 plan, or the Subchapter 5 plan, but it cuts off any future lease obligations. But more importantly, this gives you a tool to renegotiate with the landlord, because the landlord, they don't want to lose the tenant. They have vacant space, that's not good for them. So they're going to be willing to listen to you. So just the threat of a subchapter 5 gives you an ability to leverage possibly renegotiating that lease. And if worse, just terminate it, find a new lease, more advantageous lease. Bank debt, like I mentioned before, there's an automatic stay. This is going to put a stop to any sort of collection activity, stop that self-help by those commercial lenders. Tax liabilities, as I mentioned before, you can take delinquent tax liabilities instead of, the IRS, if they're coming after you, they typically want you to pay that in a single payment. With a subchapter 5, you can take those delinquent tax liabilities and put it in a plan where it's going to be paid off over a 3 to 5 year period of time. So it gives you time. It gives you time to keep your business going. And then lastly, vendor debt, pennies on the dollar. In this situation, vendors are typically unsecured. And because of that, you have the ability to cram down what they're due and pay them sometimes as low as 10 cents on the dollar. Now, the one thing you got to be careful though, many times in a small business setting, you may have a personal guarantee. So subchapter 5 bankruptcy is not going to protect the individual owners if there is a personal guarantee. So you got to be careful in that situation. I know there was a lot of material there, and I'm just trying to respect everybody's time, but do you have any questions?
Ted, what if the tenant has personally guaranteed the lease? How was that affected by the bankruptcy situation?
Yeah, as I mentioned, a personal guarantee, in the eyes of the law, the individual guarantors are separate legal entities from the business. And so if you have a personal guarantee, that's really going to reduce your leverage in that situation, because then the landlord is their response is always going to be, well, yeah, you can terminate the lease, but then I can have recourse against you individually. So certainly that is a factor that will come into play. And you may have to, in worst case scenario, personal bankruptcy is something that can be considered as well.
Would you recommend that potential tenants do everything possible not to have to sign a personal guarantee? We're moving in that direction in our office, so I just wanted to get your feedback on that.
For sure, absolutely. I mean, when a client comes to me and they're negotiating a lease, naturally the landlord is going to ask for the guarantee. But again, like any other contractual term, it comes down to leverage. If you have landlord has space that's been vacant for a number of years, I'm going to tell my client then you should say no to that guarantee, because chances are that landlord is going to be desperate to get a tenant in there. And if you can negotiate away that guarantee, then it puts you in a much better situation for sure.
Thank you.
All right. Josh, you still there?
Still here. Just been waiting in the wings.
All right, Josh, why don't you take us away and deal with staff reduction, sick and family leave, and other employment law issues.
Sure. Thanks, Ted. So just kind of an overview of the topics I'm going to discuss. The first thing is been a topic throughout this pandemic is the ability to furlough and lay off employees, what the differences are and what's right for your business. And then I'm going to talk through the Federal Families First Coronavirus Response Act, which mandated a new paid sick leave and expanded the existing FMLA requirements. Then I'm going to talk about the CARES Act, Coronavirus Aid, Relief, and Economic Security Act, that's impact on unemployment and some other recent changes to unemployment in Illinois. And then finally, just an overview of best practices for handling employees who are diagnosed with COVID-19, how to deal with other employees who might have been exposed, and just overall reducing employers' exposure. So starting just with the first topic of staff reductions and how to go about that. And throughout this process, you've heard a lot more about furloughs than we have in the past. It's kind of been a trendy word, furloughing employees, but people, I realize, don't really understand totally what that means. So when you're talking about the difference between a furlough and a layoff, what a furlough is, it's a temporary reduction or elimination in an employee's work hours with the intent to reinstate to full employment. So it's not a separation from employment. You're reducing hours, you're reducing days at the office, days working, with the intent that at some point in the future, the employee is going to be reinstated to their full employment status. On the other hand, a layoff, also referred to as a termination, is a complete separation of employment, meaning the employee no longer has his or her job. In Illinois, it's an at-will state, as most of you probably know. So either a furlough or a layoff is an option at any time, as long as it's not prohibited by some sort of written employment agreement or a collective bargaining agreement, something like that. But at any time, in most cases, employers have the option to either furlough or lay off their employees. Now, when you're dealing with these, how you handle it to some extent depends on whether you're dealing with a salaried or an hourly employee. Both types of employees can be furloughed, but you have to be careful when you're furloughing salaried employees. The general rule is that salaried employees are paid a full week's salary for any week in which they work. So really they should be furloughed in week-long increments. If you cut them back to less than 5 days a week and start to pay them less based on that reduction in hours, it could screw with whether they actually are a salaried employee, and you could be accused of not paying their full salary because they worked a day in that week. They technically should get their full weekly salary. Alternatively, instead of cutting back hours, employers can just simply reduce a salaried employee's salary with the employee working the same amount of hours. The issue here is if it's not done correctly and communicated in the right way, this could cause a salaried person to be seen no longer as a salaried employee for legal purposes, making them eligible for overtime, which obviously would be a big problem, and it would cut against the whole point, which is reducing payroll. Another issue with both of these is the compensation that's due when the action is taken. One major difference between furloughs and layoffs is that in the case of a layoff, because the employee is being terminated, that employee must be paid all their earned wages and their unused vacation time at termination, making it a very costly thing to do. With a furlough, because there's no real separation of employment, that employee technically is still an employee. They obviously have to be paid everything they've earned through the date of that furlough, but they do not have to be paid out for that unused vacation. They keep it, and when they are reinstated at a future date, assuming they are reinstated, they can continue to use it. One other thing to think about is obligations under the WARN Act. The Illinois WARN Act, which is a counterpart to the federal WARN Act, applies to employers with more than 75 full-time employees. So for a lot of employers, this is not a concern, but for larger employers, it is. And what the WARN Act does is it requires those employers to give employees at least 60 days notice of a plant closing or a mass layoff. And if the employer does not give that requisite notice, it can be liable to pay those terminated employees for 60 days of additional wages. Now, there are exceptions to the WARN Act for unforeseen business circumstances and natural disasters. For instance, if the employer did not know that it was going to have a mass layoff in less than 60 days, it won't be obligated to pay the full 60 days of additional wages. And it's still playing out. You would think that COVID would be considered an unforeseen circumstance that would create an exception to the WARN Act's obligations, but we're just going to have to see how that plays out, as obviously litigation will be coming in many areas, and that's one of them. Moving on to the next issue, the Families First Coronavirus Response Act, the FFCRA. Like I said, this was one of the early laws that the federal government passed, and what it did was it mandated a new paid sick leave, and it expanded FMLA's requirements. The law applies to employers with less than 500 employees, so I'm guessing most of the people that we're dealing with, most of the businesses we're dealing with, it's relevant to them. Under the new paid sick leave law, employees are now entitled up to two weeks of paid sick leave for a variety of circumstances dealing with COVID. So, for instance, if they're under a local quarantine due to COVID-19, if they were advised by a healthcare provider to self-quarantine because they're at high risk, if they're experiencing symptoms and seeking a diagnosis, if they're undergoing testing, if they need to care for somebody who's been advised to quarantine, or if they have a child who can't go to school because of COVID-19 circumstances, all things like that. In that case, the employee is given 10 days of paid sick leave in addition to whatever paid sick leave or vacation time they've accrued under normal employer policies. So even for somebody who's used up all their sick leave and all their vacation time so far in 2020, if they haven't used this additional 10 days of paid sick leave, they're entitled to take it. One of the questions early on, especially with bars and restaurants, is if we have to shut down because of government orders, are we still required to pay this sick leave? And the answer is no. This really only applies if there's actual work to be done, if the business is still operating. So if the business is just shut down temporarily because of COVID concerns or something else, the paid sick leave requirements do not apply. And there is a mechanism if you're obligated to pay out this paid sick leave. There's a mechanism for getting tax credits on employment tax returns. So that's something to think about if you have employees in this situation. Talk to your accountant, talk to your payroll providers, and see what you can do to try to recover that through tax credits. Under the expansion of FMLA, normally FMLA applies to employers with 50 or more employees, and it provides 12 weeks of unpaid leave for medical reasons. This new expansion actually applies again to all employers with less than 500 employees. So if you have less than 50 employees, this is something you got to pay attention to. And it expands FMLA to now apply to employees who have to stay home to take care of children who either their school is closed or their child care one way or another is not available. If an employee has to stay home to care for a child in those circumstances, they are eligible for this expanded FMLA leave. And one big difference is that after the first 2 weeks of the 12 weeks of leave, the last 10 weeks are paid, subject to certain limitations. And so normally, if an employee is out for 12 weeks due to these circumstances, they could take the first 2 weeks paid under that new paid sick leave, and then the last 10 weeks they can take paid under this expanded FMLA with job protection. So they are under FMLA before and after the expansion. They have a right to be reinstated to their position when those circumstances no longer exist. Moving on to the next slide, which looks like Ted's already on, dealing with unemployment and how unemployment has expanded as a result of the pandemic. One of the biggest changes is that under the CARES Act, unemployment is now available to self-employed individuals and also those who have already exhausted unemployment benefits if they are out of work due to COVID-related circumstances. So that really expands the unemployment pool and makes unemployment available to a lot of individuals who otherwise wouldn't be entitled to it. Early on, the benefits, the unemployment benefits, were increased by $600 per month. You probably heard that within the last month or so, that benefit ran out. Just recently, Illinois did get a grant from FEMA that enabled the state to increase unemployment benefits by $300 a month. But the word is that that's actually going to run out, I believe, in the next week or two. So we'll have to see what happens after that and whether a new law is passed or something's done to increase those unemployment benefits. Otherwise, they're going to go back down to their normal levels. Also, Illinois recently announced that individuals are going to be eligible for an additional 20 weeks of unemployment, normally capped at 26 weeks. And under the CARES Act, I believe that was increased by 13 weeks. Illinois is providing an additional 20 weeks to help individuals, I guess, survive and get through this pandemic, hopefully as unscathed as possible. Just another topic there. One question we've gotten from employers a lot is, should we have our employees sign some sort of waiver asking if they're exposed to COVID-19 while on the job, or if they actually are infected by it on the job, holding the employer harmless? And our response has actually been that for a couple of reasons that probably is not effective or the best idea. One of the big reasons is that as the law stands now, if an employee is infected with COVID-19 while on the job, that gives them the right to make a workers' compensation claim. So any lawsuit against the employer would be preempted by a workers' comp claim, and the workers' comp laws don't allow for an employee to waive their right to file that claim. So likely it's going to be ineffective in the first place. And second, if you're going to have something that's not effective, the downside of it is that it's probably not great optics with your employees if you're asking them to waive any rights to recover for getting sick on the job. Probably doesn't boost morale. So our thought has been, given that it's likely not effective legally and that it's probably just not a great look with employees, we've been telling our clients probably to stay away from having them sign COVID waivers. We have had our clients use COVID waivers with their own customers and clients if the circumstances are right, because as the law stands now, those can be enforced. But with employees, it's probably not the best idea. And then moving on to the final slide, a related topic, dealing with employees who are diagnosed with COVID-19 and how to notify other employees about those circumstances. In terms of the employer's obligations, just generally speaking, employers do have a general duty to maintain a safe workplace, and that generally would include advising employees of their potential exposure to infection. So if an employer determines that an employee is infected, it's definitely a good idea and probably mandatory to let all the other employees know of the issue, and to the extent possible, alert any employees who specifically have been exposed that they may have come in contact with the infected employee. But at the same time, you have to protect your employees' information. You can't necessarily just tell exactly who was infected, because at that point you're disclosing confidential information and you're putting yourself at risk. What you can do is talk to the infected employee and see if they would be okay with you releasing that information. If so, you'd want to get that in writing, or have them communicate it to their coworkers themselves. Obviously, the more information that's out there, the more protected the other employees can be, which is the name of the game. And that's basically all I have on that topic. At that point, I can open it up to any questions. All right. Thanks, everyone.
Okay, there was one question that I missed that was posed earlier on. I think it was related to business interruption insurance. One person asked about getting your insurance company involved. I suppose this is in the context of dealing with creditor issues or contract issues. First of all, you have to have the coverage. You paid for the business interruption coverage. But second of all, most of those policies typically require some sort of physical loss, some sort of, like your building being burned down, or some sort of physical loss to your premises that would interrupt the flow of your business. Now, there is some pending litigation I know out there, and I'm going to be very curious to see how those cases are ultimately resolved. But right now, most insurance companies are denying any sort of business interruption coverage. And with that, I'll turn over to Lisa.
If I could just expand on the insurance question.
Sure.
And yes, you're absolutely right with the business interruption. I mean, it's right in there that viruses are excluded, but that doesn't mean people aren't being sued over it. But I was talking more about when a client sues you, and it can be for a variety of reasons, but if you have E&O insurance, or if it's a product liability or something like that, when do you as a law firm get involved with the insurance companies? When do you advise your clients to start the claim?
Well, if you're sued by a client for some sort of malpractice or some sort of liability of some sort, I always advise our clients to notify your insurance carrier as soon as possible, because if you fail to do that, you may be faced with an argument for them later on that they were prejudiced by your failure to notify them. They weren't able to defend you in a timely manner, and therefore even if you may have coverage, those insurance companies may try to avoid covering that particular loss. So that's number one. I would say that right away. And then beyond that, certainly, sit down with your lawyer, review whatever the complaint is all about. And you have to evaluate whether there's any sort of risk of liability there under the facts and circumstances. But we generally try to encourage our clients to notify the carrier as soon as possible.
Thank you.
Yep.
And Ted, I had a question that came in as well. And the question is, does a business have to be viable in order to reorganize under subchapter 5? For instance, if a business is directly related to conventions that come to Chicago, those conventions will probably not resume until a vaccine is in place.
Yeah, it's a good question. So for subchapter 5, you're going to be proposing a reorganization plan. That plan is going to take all that delinquent debt, delinquent liabilities, and you're going to take that and you're going to propose a plan to pay that in the future over a 3 to 5 year period, depending on the plan. But in order to do that, you have to have some sort of core business that is going to generate cash to, first of all, cover your variable costs, such as your wages for your employees and rent and other ordinary variable costs, but then you need a little bit more beyond to go towards that chapter or subchapter 5 plan. So you do have somewhat of a viable business in order to be successful with a subchapter 5.
Great, thank you. Any other questions from anybody in the room? Feel free to unmute or send a message.
And I would also add, we would always sit down with any potential new client, provide them with a free consultation, or if you just want to shoot me an email, you know, if I don't have the answer, we have many attorneys here, we can find an answer for you, you know, don't hesitate to do that.
This has been incredibly beneficial. Thank you so much, Steve, Ted, Josh. We really, really appreciate it. Just a reminder, there were 2 companies that were doing raffles. That would be Amy with Harper College. So if you find her in the chat, shoot her a quick message, and also Brittany Street with Links Technology. Brittany, are you potentially ready to share
ready
and a little about Links?
Yeah, so Jim kind of explained a little bit earlier, but Links is a family-owned, veteran-owned technology firm. We're located right in Schaumburg, and we do everything technology from like website design, app development, IT staffing, and many managed IT services. Some of those services are co-location, business continuity plans, and security awareness training. But today I did want to offer a raffle. Winner is Tom Goosh. We are giving away a QR code that's customized to your company. We can put your logo in it, and you can have it on the front door of your facility. So if you want to assess any COVID symptoms, you can. They will just scan the QR code, and they'll be prompted to go to a short little survey that's about 5 questions. So congrats on that.
Thanks, Brittany. And Amy with Harper College, yes.
Good morning. Harper College, we are located in Palatine. We've been a member of SBA for many years. As a lot of businesses know and have worked with a lot of our business resources, like our Small Business Development Center, our Harper Business Solutions, which provides customized training, our Job Placement Resource Center. Even though the campus is closed, all of those departments are still operating, offering virtual training, job postings, all of those different services. So we're still out there supporting the businesses in the community. You can find out more information about all the business resources, because there's many more beyond that, at harpercollege.biz, and I'll put that in the chat. And also, if you go to harpercollege.edu, one of our newest announcements is a brand new scholarship specifically related to COVID-19. It is specifically for people who have lost their job or have been affected by the pandemic. It is called our Moving Forward Scholarship, and it's specifically geared towards our continuing professional education programs. And one of our newest programs in that area is our contact tracing, which is, there's a very, very high demand for contact tracing right now. So it covers full tuition as well. So it's there to help people find a new career, new training, and get back on their feet in any way possible. But if you go to harpercollege.edu, just scroll down to the bottom to our new news bureau. There's lots of information about that. And I do have raffle items as well. I'm going to do 2 this morning. And Lisa, I'm going to employ your help if you can. Can you give me a number between 1 and 5?
Definitely 4.
4? Okay. And can I have one more number?
1.
Okay. So D is one of our winners, and Tom is our other winner. Tom's like a double winner today. Look at that. And it wasn't even rigged. So D and Tom, I have your emails. I'll email you guys. I'll be mailing out your prize package. I'll email you directly and get your mailing addresses. Thanks.
Keep information going to the business community to make the best decisions possible for your business. So with that, if we can move to the next slide. So we did a survey for our members. We've been surveying our members quite a bit. The last survey indicated 70% of those individuals who completed it said they wanted to start transitioning to in-person events. So we had, tonight was a scheduled business after hours that was at Topgolf. It still is at Topgolf. They have reopened. They are inside, outside. And we are doing a business after hours in person tonight at Topgolf from 5 to 7. We will be adhering to IDPH guidelines as well as CDC guidelines. Masks will be required. If you are eating or drinking and sitting down, you can take your mask off to eat or drink, as well as if you are in the bays to golf. It is recommended, but it will not be required. And we do have 2 floors of Topgolf tonight. So we have just under about 100 individuals attending. If there's anybody on this call who has not made the RSVP list or is on a wait list, let me know. We'd love to get you in.
Hey, Leeds.
Yeah.
What time is the Topgolf, or not the Topgolf, the golf outing? What's the time?
The golf outing? The golf classic is tee off at 8:30.
Okay.
And the ladies golf outing is tee off at 10:30.
Got it. We're not doing any dinner. You're not doing any of the other stuff, right? There's no big gathering after or any of those kinds of things.
There is not. So what we are going to be doing is we're teeing off. It's earlier than general. So you'll be assuming coming back to the clubhouse around 1:30 or 2 o'clock. We're going to have a pig roast.
Got it.
And chicken. And it's we'll have tables inside as well as outside. So again, we'll be less than 50 in any one spot. And we'll also have to-go boxes. So in the event you did not want to stay, you can grab your food and take it to go. The awards will be handed out. Well, not handed out. Awards will be announced at 4 o'clock. We're going Facebook Live for both the Golf Classic and the Ladies Golf Outing. And we'll be acknowledging who won each of the contests, who was the best foursome for both the Golf Classic and Ladies, and also announcing who the raffle winners were. But that will be Facebook Live. And then we also, for those who were on at the beginning of this call early, Tom Ghosh is going to be speaking at our Coffee and Contacts event happening on September 24th. That's going to be a virtual event, but he'll be sharing 5 secrets to creating dozens of sales volunteers for your company. And in a recap of today, I'll not only be sharing this presentation, I'll also be linking to our COVID page, and Tom has put together a pretty awesome video that I'll also be sharing. And as Jim Burke had already had a question regarding our Golf Classic and Ladies Golf Outing. These generally happen in the summer. We've pushed them back. They are both happening on September 28th. However, we are staggering them. Golf Classic, golfers that come early, they head out to the course, and then the Ladies Golf Outing. Lady golfers will then come. Ladies Golf Outing, if you have not yet been a part, we do a caddy auction. It is a hysterical day. It is truly networking on the golf course. There's always a few foursomes that are in it to win it, but otherwise it is just a great day on the course. And as I mentioned, we'll be wrapping up probably around 1 or 2. And then our annual gala, the Toast of Schaumburg, that generally happens in the fall. We are having it this year. It is entitled Illuminate, and it will be a celebration of resiliency and ingenuity. It'll be held on Friday, October 23rd, and more details will be emailed out later today. Rather than having everybody in one location, we're gonna be celebrating everything that is Schaumburg in about 5 different locations throughout different restaurants. Your ticket price is going to be based on which restaurant you would like to dine and celebrate with us at. And think New Year's Eve with Carson Daly. We'll have cameramen at each restaurant. We'll have a host at each restaurant, and we'll be going. So wherever you choose to celebrate the Toast of Schaumburg this year, we hope it is with us on October 23rd at any one of these restaurants, or even at home, because we do have a virtual option as well, where you will get a little goodie bag as well as a signature wine glass to do the official Toast of Schaumburg. And then lastly, our Women in Business quarterly series is on October 7th. And I know the chat's been blowing up. If there's any resources that have been shared in the chat, I'll make sure to send that as well in the follow-up email. Thank you all for joining us today. Any last words from anybody?
Stay safe and sane.
Stay safe and sane. Love it. Thank you all. Enjoy beautiful sunshine. Have a great one. See you soon.
Yeah. All I do is win, 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 no matter what.